Thank you. You may be seated.
Calling the people versus Carlos Hernandez, case number 2024-291-945 FC.
John Petrofessa, Andrew McGarrow on behalf of the people.
I see you.
Michelle Loftton on behalf of the defendant, Carlos Hernandez.
Can I tell me your name?
Carlos Hernandez.
Okay, we're ready for closing then?
Yes, Your Honor.
Okay, we will bring in Mr. Hernandez's jury. You can come right in here. Welcome back. Please be seated. Ladies and gentlemen, I apologize. Obviously, my estimation was significantly off, but we're ready to go. Go ahead, Mr. Petrofessa.
Anything support? Counsel? Good afternoon. There's been a lot of evidence, a lot of testimony, experts who've testified. It's been a very intense 3 days. I understand that. Ms. Loftton understands that. And as I stand here before you, I'm always thinking about what do I say at the end of the case when I know you've all paid attention. I know you've taken notes. And I actually saw something on TikTok last week that made me think about this, which was a guy was talking about the difference as you go through life between your perception of things, which is how you walk through life and you look from your set of view to what's going on around you. You see your family, friends, work. That's your perception. But there's the perspective. If you step out of yourself to look back at you in that picture, you in the group of everything that's going on around you. And that's really what I think about now, because from my perception, I don't need to make any closing argument at all. I believe you've paid attention. The judge is going to give you the law. And I really don't need to say much more than what you already know. But I don't have your perception of what's going on. I can't assume that. So I'm going to say a few things about the case and see if I can address things efficiently. I'm not going to go through everything that you've heard in depth because we could take another hour to go through the text messages like we did this morning. You've paid attention. I'm going to try not to be redundant on things that you've already incorporated in your view of what's been going on in this courtroom for the last 3 days. The judge will instruct you on the law, and we talked about it in jury selection, and it is a first-degree murder case. But to be very clear, it is not a premeditated first-degree murder case. That is, I don't have to prove premeditation. I don't have to prove that on the night of October 10th or the day of October 11th last year, they intended to kill Mr. Murray. That's not what this charge is. That's not part of my proofs. All I have to show regarding felony murder is that on that day, on October 11th, their intent was to commit a larceny. And then in the commission of that larceny, as they were doing that larceny, as the judge will instruct you, the death of Mr. Murray was either because they intended to kill him, or they intended to do great bodily harm, or created a very high risk of death or great bodily harm in that commission of the larceny. And you're also going to hear, which we also discussed during jury selection, anyone who intentionally assists someone in committing a crime is as guilty as the person who directly commits it. And as you know from everything that's been presented, on October 11th, 3 people went down into that basement, but only 2 people returned from that basement. And I cannot tell you what Mr. Murray saw because he's not here. I will tell you that what you've seen in this case, especially today with the text messages, I believe it shows very clearly that this was a plan both before, between the defendants, during, and then after. And the plan was to get rich by robbing the Murray's home that day. They had a belief, which was false, that there was a lot of valuable things in that house. And there wasn't. The only thing of value that was taken on October 11th was Mr. Murray's life. That's the only thing of value. The rest of it is almost junk as far as value. A cell phone, some cash, junk. But that's what their intent was. And that intent, as you've heard, started in the process, in the works a year earlier in 2023 in October, almost exactly a year earlier, when this defendant started to have his dealings with the pawn shop of Mr. Murray and Hamtramck. He would go to that pawn shop, he would pawn items, he would get cash, he would have contact with that pawn store, and then you heard in February of 2024 he returned. And when he returned in 2024, as you heard from Hannah Hussein, he asked, as he was looking at the Rolexes, and the Rolexes I think have a secondary importance when you see what happened and what you saw happen at the scene. He sees the Rolexes, he spends a lot of time, 10 minutes looking at the Rolex case, and then he asks her to see the owner. And she brings the owner to him. And the owner looks him in the eye, shakes his hand, introduces himself as he's wearing a Rolex, as he has a necklace on, and that's a solid identification of how the first connection between the defendant and the victim occurs. And you heard in that statement that was played yesterday, when he's paddling everything he can to stay above water down in Cato Parish, and he throws out there, because the detectives don't have everything at that point. It's very fast. The investigation happened. It was successful, identifying the defendant very quickly. And part of it is from the obvious. You don't have to have known the defendant for your entire life to see that Ring video and say, oh, that's the defendant. Very distinctive. The focus was on him quickly. But in Cato, if you remember what he starts saying, well, this was set up by some third guy. He starts coming up with this. He was identified, the victim was identified by a third guy. No, it's not a truthful story, and you're trying to get yourself as far away from what happened as possible. In fact, you knew the victim directly. You saw the victim directly. And at that store, as you heard, Mr. Murray's Audi was always parked in the same location outside that store, visible to folks who would come and go, just like it was parked visibly in front of his house. You hear that as time develops, and he's back here in 2024, in September, you start seeing very clearly by text between the two defendants about creating this plan to get into Mr. Murray's home. And they also intend to get away with it. They're not trying to get caught. They plan on getting out of there. And what, as you see through the text, tightly linking it, what are they gonna do to get out of there? The first text between the defendant and Zuazo, and also Amanda, has to do with stealing a vehicle. He texts, we need to steal a car. Okay, why is that? Well, because he doesn't want to show up in Rochester Hills in their in their Jeep, with their plate on that Jeep that can be tracked back. As we all know, the Flock system tracks plates like that these days. I had no idea Lowe's tracks plates like that these days also. So license plates are a very quick way for law enforcement to identify folks. So they're on it. They're planning to steal a vehicle. And then, in fact, as you hear from the owner of that pickup truck, his vehicle was stolen, I think, on September 30th of last year from out in front of the house. So now they have that vehicle, but that vehicle has a very identifiable plate. Poco was the company name. Poco is part of the plate. So to disguise it another level, a DTE license plate gets stolen to put onto that vehicle. Poco is replaced for an actual DTE plate. That's the level of disguise that is going through, and that disguise is to get in the house and to get out of the house without getting caught. Now, you've seen the text as it progresses. The defendant is coming up with ways to make that truck look like a DTE vehicle. He is going in person on video to order that DTE nameplate for the sides of the truck. As he's doing that, he's sending those samples, his proofs of what it's going to look like to the co-defendant. And as he does that, he's also on video picking it up. The poor guy who owns the sign company was so afraid that he was somehow involved with the homicide, he immediately calls the sheriff's department after it takes place. So then you hear what else they're doing to try to disguise their appearance. They're going to Home Depot, they're going to Lowe's, they're getting other type of work materials that would look like they're DTE people to disguise themselves. You see Zuazo is communicating with one of his buddies who actually worked with DTE and had DTE equipment and helmets to get that as part of their plan. And then they're ordering at Home Depot duct tape. And after they get the duct tape, you'll hear that the plan is in place now. They're basically ready to go. But there's something that they weren't able to prepare for and buy at Home Depot or Lowe's. Something they needed to accomplish that. And that something was the will to do whatever was necessary to get into that house and to commit that larceny. That will to do that, that comes from in here. That you can't buy. So equipped with all the things that they have pre-planned, they head to Rochester Hills on October 10th, late. They have an entire long drive to get to Rochester Hills. They don't turn around, they don't leave, they don't decide not to do it. They show up at 10 o'clock. And when they go to that door, which has Ring cameras, and I think you'll remember in passing the deputy within seconds of getting there, before he's even been inside, he says there's Ring cameras all around this house. They're that visible. They're not secret Ring cameras. So you're on Ring camera. And as they get to this house, who's leading the way to the door? This defendant. He's at the door first. He's the one who's making contact. He's the one who's the knock on the door. And Mrs. Murray's alerted on her phone because everything bounces to the phone from Ring camera. And Mr. Murray is downstairs while she's already upstairs getting ready for bed. And as he goes to the door and answers the door, and there's the defendant with the co-defendant behind him, dressed like DTE, trying to disguise their face with the mask that they're wearing. He said, we're here to check the gas leak, we need to get in the house. And Mrs. Murray, who's hearing this from upstairs, says, isn't it a little late for a gas check? And the defendant continues talking to Mr. Murray. And she yells down, Sam, do you have your gun on you? And she said it loud enough with the intent for the folks at the door to hear it. And we know that her husband did have a gun and that he would carry that gun. So as that's being said, her husband isn't letting him in at 10 o'clock. There's no smell of gas in the house. So, no, I'm not letting you in. And the defendant has a clipboard to make it look like they're there to get permission and consent. It's even part of their text messages about making it look like there's a consent form when you go to the door. More ways to trick the Murrays into letting him in. It wasn't happening on the 10th. The defendant says, we'll be back tomorrow. And he leaves. And that door shuts. And we've talked about before in jury selection unanswered questions. And there's unanswered questions about why did they leave that night on the 10th. And those questions don't have to do with the elements to prove about what happened on the 11th. But, you know, when you're opening that door and you've heard Mr. Murray is not a small person, 6 foot tall, nearly 300 pounds. And then you hear it accompanied by Mrs. Murray saying, do you have your gun on you? So now you have the defendant who's the first one closest to Mr. Murray. So in those moments, was there a calculation that he was not going to be able to get to Mr. Murray before Mr. Murray could back up and pull his weapon? Was there a calculation that if there was going to be a struggle, it was going to take a while? And you also heard that Mrs. Murray was at the top of the stairs. And I don't know what calculation could have happened if they had gone in at that moment, but there was no way they were getting up those stairs to Mrs. Murray on the second floor before she dialed 911. No way. There wasn't any way to accomplish that. So they leave and they drive back, a long drive back. And in that drive back, do they decide, we're not doing this again tomorrow, this is a mistake? Do they decide that we're not gonna go against the ring cameras, we're not gonna go against Mr. Murray, we're not gonna go against the potential that he's armed, we're not gonna go against the Oakland County Sheriff's Department if they're called, we're not gonna go against the law? Do they decide that this is a bad decision? No. Instead, they're already texting that night between the two of them about the plan for tomorrow. What time am I gonna get picked up at? And they also decide that whatever they brought on that first trip on the 10th, it wasn't enough. The plan had changed after seeing Mr. Murray at the door. Now they wanted the extra long zip ties. And those are the extra long zip ties you see, unfortunately, in that gruesome scene in the basement. Those are the extra long zip ties that you see were put into a position where it could be used like a handcuffs left on the floor because they never got that far with that set of zip ties. And at 9:30 the next morning, the defendant is back to picking up the co-defendant and headed to Lowe's. And they're headed to Lowe's to make that purchase of those zip ties and take another run. They're not going to be thwarted from getting into that house. Nothing is going to stop them from going through that house looking for riches that don't exist. And they show up that next morning at about 11. And they show up in that DT vehicle. And you'll remember Mrs. Nyhouse, who's walking her dogs, says, I noticed a sound, and I wasn't really, it's just a weird vehicle sound. And, I look over and I finally see this slow rolling vehicle, but it's marked with DTE. And at that point, I wasn't concerned anymore because I figured they were there just going through the neighborhood. Yes, they were successful. They had tricked the neighbor into thinking it was a legitimate DTE vehicle. So now they get out of the vehicle and go up to the Murray's home to trick them to get into the house. And unfortunately, this time it worked. And you'll hear how, once again, Hernandez is leading the way through that door. And you heard again how they're saying they're there for a gas leak, which doesn't exist. And then you hear that once they get into the house, they want to get down into the basement. For some reason, they think the safe is down in the basement. So once inside the house, as you hear, Mr. Murray goes down first, the co-defendant goes down second, and then the defendant is following behind. And Mrs. Murray doesn't think anything is off at this point. She goes back to the kitchen to continue making breakfast. She says she's there 10 or 15 minutes, doesn't hear anything from downstairs, doesn't hear a commotion, doesn't hear a scream, doesn't hear anything. And as that 15 minutes goes by, she's finished with her breakfast making, and up comes Defendant Hernandez first. And Defendant Hernandez comes up from downstairs. They're close to each other, and he starts immediately, where's the safe? Where's the money? Where's the jewels? Now, it's instantly apparent that this is no longer a DTE visit. And she starts saying, we don't have much cash. I got $300 that's in my purse. Where's the safe? We don't have a safe. There's no safe here. Where's the jewels? There's no valuable jewelry here. He continues asking about that. And within seconds up comes Zuazo, as she said. There was a very brief time period difference, not very long at all. And as she's asked about where's my husband, Zuazo shows up. And she says, where's my husband? And he says, well, he's sleeping. And then she sees the blood on his front of his shirt that he's wearing. And she immediately starts screaming. And what does the defendant do? He hauls off 6'5", 450 pounds and punches her on the left side of the face. You saw her injuries that were later photographed. That's a real hit. Are you going to keep screaming? No. So then what does he do? He starts to duct tape her. The larceny is still going. The larceny isn't over. They got a gun off of Mr. Murray down in the basement. They got his gun, we know that. And Defendant Zuazo goes upstairs and starts ransacking because they're still looking for things to steal. The defendant is going through her purse, taking cell phones, taking cash, going through kitchen drawers to find those things. Larceny's not over. He doesn't go running out of the door. Zuazo doesn't go running out of the door saying, this is over, this is ridiculous. No, they're continuing with the plan. And that plan was, as you saw in the text messages, the defendant wants to buy a house with what they expect to get from this larceny. They want to buy a house. They don't want to work hard and save up for it and do all the things that you have to do to be able to buy a house. They want to go in there and steal for a house. They want to go in there, and if it takes ending Mr. Murray's life to get that money for a house, so be it. And as you hear, she's getting duct taped up by the defendant. Zuazo comes down with the drawer of jewelry. And then what? You think that it's over then? No. They both want to put her in a closet before they leave. Let's put her in the closet. And they try to put her in the closet. And they're not able to put her in the closet because of the way she's taped up. So she's left there without her cell phone, and they leave. And as soon as they leave, they continue doing what they want to do from the beginning, which is to get away with it. So they take that truck down to Detroit, because that's direct evidence. They're in that truck. There's probably going to be DNA left in that truck, and they set it ablaze. That truck goes on fire. And then you see the vehicle being followed by the defendant's wife within minutes to where the truck is found blown up within minutes, because he's still trying to get away with the larceny. So as the investigation continued, the sheriff's department very quickly, very wisely put out that video to the media. And that video went out on the media quickly, and the defendant was quickly identified as being one of the two people in it. Physically distinctive. And as they do that, they start figuring out what vehicles are registered to him, where does he live, does he have any other residences, and they figure out his Jeep, they figure out the Texas residence, they figure out he's gone from where he was staying up here with his mother-in-law. That mother-in-law who identifies him as being the other person in, one, the Ring camera, and then also identifies him as being on that Lowe's video. She did that in front of you. She'd never had the opportunity to see the Lowe's video before. She identifies both defendants an hour before this. At that point in time, they're stopped in Louisiana. Louisiana takes everything into evidence, and at that point, you hear when it's brought back all the things of significance that is in there from Louisiana. You find the size 13 shoes, boots, that belong to him, and you see 2 pairs of 13 sneakers that weren't connected to this. So he has 3 pairs of 13, and on the bottom of those 13s, you'll see blood was discovered, and then you'll see that he's collected a lot more of the evidence that didn't even belong to him. He has Zuazo's boots. You know, he's probably tasked with destroying some of the evidence, and he's keeping that. Is he keeping that to negotiate something down the road? Who knows? But he kept it. He still has the DT clipboard. He still has the DT sign. He still has the POCO license plate. He has all these items with him, including the stolen jewelry. So, what you see down in the basement, which is absolutely brutal, what you see down in the basement is, and I think very obvious, that Mr. Murray was putting up a struggle. Okay? The only blood that's ever found is Mr. Murray's blood. There's no blood of the defendants. There's DNA of the defendants, but it's not DNA from blood. But he's struggling. And when he's struggling, no matter how big or small either of the defendants are, when you're struggling, they had to bind his hands. They had to bind his mouth. And they bound the hands with both duct tape and those zip ties. And why it's important, and I think it shows, not just because the doctor said the blood is in his lungs, which means he's bleeding, so there's already been that physical altercation, and he's bleeding and inhaling it. That doesn't happen if you're already dead. You don't breathe and inhale once you're dead. And at that point in time, you see very clearly in the photos, that Rolex is bound underneath those zip ties. It's bound in a way that even the ME said no, but it was secured under those zip ties. Because Hernandez likes the Rolexes. We know that, coincidentally. If he could easily have gotten that Rolex off, that would have been the most expensive item to take from that scene. But he wasn't able to do it because there was a struggle going on. You heard the multiple blows that Mr. Murray sustained in multiple areas of his head, of his face, consistent with the butt of a gun that was never found, that was taken out of there. The money was never recovered. The cell phones were never recovered. But what was recovered was the defendant's t-shirt, XL6 size, that has the victim's blood on it. What was recovered was the duct tape rolls in the basement that has both defendants' DNA on it. And the other thing that you can't escape, defense is going to have a closing. I don't know what they're going to say, but you can't escape saying he's not part of that bloody scene. He wasn't upstairs when that happened, because if he's upstairs when that demolishing of Mr. Murray occurs, there isn't going to be Mr. Murray's blood on his t-shirt. There isn't going to be Mr. Murray's DNA on the bottom of his shoes. And you also heard from the crime scene that they took kind of a special type of thing to uncover any type of blood evidence that was down there. This is admitted into evidence. I'll show you what's been marked as and introduced into evidence as exhibits 3K, 3O, and 3M. The black 13 Nikes from both sides. But look at that distinctive pattern on the bottom. That is unique. That's unique to the eye. Now there's blood found on these shoes. And that's the victim's blood. But say he's not down there when this occurred. Exhibit 2AA and 2BB. Look at that pattern that's left on the bottom of that floor. The unique ridge line on the side of those shoes on the bottom. I'll have an opportunity to address you after Ms. Loftton is finished, but I appreciate your attention.
Go ahead, Ms. Loftton. Thank you. Good afternoon. It is quite clear that you have been an attentive jury and you've paid attention to all of the evidence and taken notes when you felt it was appropriate. So I'm not going to stand up here and go over every single thing that we have heard in these last 3 long days. But it is important to go over a number of things that you heard and some things that you didn't hear. Since it's the prosecutor's burden, as he just mentioned, he gets to speak to you twice. So I apologize in advance for my long-windedness, as I only get to speak to you once. We have told you many times that you, as juror members, are here to piece together what happened on October 11th, 2024, in the city of Rochester Hills. As you were told in voir dire, the prosecutor must prove each and every element beyond a reasonable doubt. The prosecutor carries a very heavy burden. This doubt can be created by the evidence presented, but also by the lack of evidence that the prosecutor brought forth. Now, we saw a Ring camera video from October 10th. Clearly shows that in the evening, 2 individuals came to the Murray's home and asked to come inside to look for a gas leak. They were turned away. We also know from Ring camera footage that the following day, in the morning at 11:22, the same individuals returned to the home, and this time they were let in. We know from the garage Ring footage that these 2 individuals left at 11:41. So we are talking about 19 minutes. We also know that the 911 call was placed at 11:47 a.m., within 5 minutes of these 2 individuals leaving the home. We heard from Deputy Copeland and actually got to watch his body camera. He was the first responder. You can tell from that body camera that he responded and got out of his car at 11:54 a.m. Officers do not enter that basement until 12:08 p.m. He, in fact, does not check for a pulse until 12:13, after saying, "I know it's silly, but what the hell? I will check for a pulse." The paramedics arrived even minutes after that. He testified, and you could hear from the comments that were being made on his body-worn camera, that he believed that Mr. Murray was shot in the head, which is usually an untreatable situation. We know from Dr. Shauna Bryan, the medical examiner, that Mr. Murray was actually still alive after the assault occurred because blood was found in his lungs, and also based on the fact that there was a large amount of blood found on the floor around him. And as the doctor explained, his heart was still pumping. It was 30 minutes from the 911 call until someone attempted to render aid. Another important detail from Deputy Copeland were his comments that he found blood on the wall and the handrail leading to the basement. This blood swipe is very similar to the one that we heard and saw that was located upstairs near the bedroom. And who did we find out was the only person that went upstairs? Mr. Zuazo. We heard from Valerie Myra, the forensic lab investigator. She was responsible for taking the photos and assisting in the processing of the scene. She told you that when collecting evidence, you never just toss it into one bag because it ruins the integrity of the DNA. She also said that when you have wet items, you put them in paper bags. You don't put them in plastic bags. She took all of the pictures of the scene and then also did some fingerprint analysis back at the lab. Now, she did photograph that swipe, that blood swipe upstairs. She was not directed to it and didn't see it or photograph the one down by the basement. We heard from another forensic lab investigator, Sierra Ramirez. She detailed her impressive academic achievements to be able to hold the position that she does. Now, she was in charge that day on collecting the evidence at the scene and then processing a number of the items for DNA. She explained that when you're collecting evidence, you need to wear gloves and wear a mask to prevent any type of DNA transfer or degradation of the DNA. You saw her not even wanting to open the package that Mr. Pietrafesa handed her without gloves and a mask. She said it is very important when collecting evidence that you put everything in separate bags. She also described that if something has a biological substance on it, like blood, and that item is put next to something that is dry, DNA can transfer. Was Mr. Hernandez's DNA on the rolls of duct tape? Yes. We know he purchased the rolls of duct tape. Mr. Hernandez's DNA was also found on a number of items that were found in the back of his car after he handled them and packed them into his car. We also know that he packed all of the items that Mr. Zuazo was wearing in a black bag, which was found in his trunk. Now, we heard some testimony from Thomas Keelan. He was the individual that worked for POCO, and he testified that his truck was stolen on September 29th. Now, like we discussed in voir dire, even if you believe that Mr. Hernandez was responsible for stealing the car, he's not charged with that. The fact that the truck was stolen does not satisfy any of the elements of the charges that he is on trial for. We also saw and heard from multiple witnesses saying that the truck was burnt. It was driven to Detroit that same day and burnt out. Again, Mr. Hernandez is not charged with anything related to the damaged vehicle. The burning of the truck does not satisfy any of the elements of what you are here to decide. We heard from Brian Broad, that was the former boss of Mr. Zuazo. We heard that he identified him from a video that was played on the news and the social media, and he immediately called the police. He also testified that Mr. Zuazo was let go due to poor performance and not following the rules, and that when he was fired, he decided to call his boss and tell him he was going to kill him. We heard from Deputy McCoy and the detective Casey Jones from Louisiana that Mr. Hernandez had an address in Katy, Texas, and that a be on the lookout was put out in the United States, and he was pulled over in Louisiana in a white Jeep. You heard that when he was pulled over, he complied with everything that was asked of him, and he pulled over immediately. We heard from Hannah Hussein. She's a family member of the Murrays and has been a store employee at that pawn shop for 20 years. She told you that in 22 and 23, Mr. Hernandez pawned items at the store that was owned by Mr. Murray. She described that in January of 2024, someone came in and redeemed the items that Mr. Hernandez had pawned. She couldn't say who that person was, but someone came in. She also told you a story that had never been previously told to police or written in a statement. Even though she agreed with me, it was an important detail. She told you at some point, which she does not know when, she remembers Mr. Hernandez entered the store when she was working and asked about a Rolex, and then asked to talk to the owner, Mr. Murray. She has worked at that store for 20 years and testified that on some days she sees 50 people. In reviewing her testimony in the jury room, I ask that you review the judge's instruction on credibility. If we are to believe that that happened, and Mr. Hernandez had an interest in Rolex watches, I understand Mr. Pietrafesa's explanation of why, that Rolex would not have been left on Mr. Murray's wrist if Mr. Hernandez was the one that was doing the assault. Does the fact that Mr. Hernandez went into the pawn shop owned by Mr. Murray in October of 2023 prove any of the required elements? I say no. Even if you believe that he went into the store in January of 24 to redeem his items, it does not prove any elements. There is no evidence to show that he had somehow been following Mr. Murray for over a year. Now, we heard from Linda Murray, and I think that Mrs. Murray did the absolute best job she could testifying. Definitely the worst day of her life. Now, she told you then that on the night of October 10th, she yelled down to her husband asking if he had his gun on him. If we are to believe that she said that loud enough for Mr. Hernandez to hear, does it make sense that they would come back the next day with no weapon? Especially not if the plan was to injure Mr. Murray. Now, she told you that she never saw any type of weapon from either Mr. Hernandez or Mr. Zuazo. Another interesting detail she mentioned was that Mr. Zuazo went downstairs with a mask. He had it on his face. But when he came back up, he didn't have a mask on. So whatever happened in that basement with Mr. Zuazo, it caused him to lose his mask. Not Mr. Hernandez. He still had his mask on. Would a man that is 450 pounds be able to do the assault that we saw the results of and walk back upstairs with that same respirator mask on? I argue no. The most important part of her testimony in relation to Mr. Hernandez was the proximity in which Mr. Hernandez was to her for about 10 minutes of the time that he was in that home. All of the close interactions that she described happened after Mr. Hernandez had come up from the basement. She told you that he used his arm to grab her and take her to the kitchen. She told you that she watched his hands as he took off her watch, as he took her phone, as he went through her purse, as he went through the drawers in the kitchen. She was within inches of him as she watched his hands put duct tape on her wrists and on her ankles. She never saw one drop of blood on him. Not on his mask, not on his hands, not on his vest. No blood was smeared or swiped on her when he did all of those things that required him to make physical contact with her. You saw the amount of blood that was in the basement. If Mr. Hernandez did the assault on Mr. Murray, there would have been more blood on him. You saw in the autopsy photos the amount of blood that was on the face when someone used duct tape to bind him. I argue it would be impossible for Mr. Hernandez to be blood-free on his hands if he was the one that did that. Just look at the swipes of blood left by Mr. Zuazo. Now, we then heard from Detective Wiegman. He is the one you saw in the interview of Mr. Hernandez, but also the detective who testified that he talked to Mrs. Murray pretty consistently for over a week and compiled his understanding from the interviews with her. I actually read from his report, and he agreed with all of the statements in it. He stated that Mrs. Murray had told him that Mr. Hernandez came up from the basement and began to ask for money, jewelry, goes through her purse, takes her phone, that there was a period of time where this happened before Mr. Zuazo came upstairs. Now, once Mr. Zuazo comes upstairs, Mrs. Murray sees the blood on him and screams. This timeline fits exactly with what Mr. Hernandez says in his interview. And obviously at the time of his interview, he had no idea what had been reported to the police. But he tells the detective, everything was fine until Mr. Zuazo comes upstairs and he has blood on him. Now, we saw a lot of text messages today that Mr. Hernandez exchanged with his wife and with Mr. Zuazo. In all of those hundreds of text messages, nothing about a gun, nothing about a weapon, nothing about killing. Now, conversations about an elaborate larceny? Absolutely. Conversations about taking things that weren't his? Yep. But Mr. Hernandez does not have a charge that you are here to decide that is alone called larceny or home invasion. Now, we heard from the medical examiner, Dr. Shauna Bryan, and she told you that Mr. Murray did not die of a gunshot wound, which was previously thought, but actually, he died after being beaten in the head and the neck. She told you that blunt force injuries could have been from an object or a fist, or some of them could have even been from a fall. That while the injuries were severe, they could have been done by someone that was just 150 pounds. She also testified it takes 6 pounds of force, or as she described, the weight of a human head, to compress the neck to stop breathing. This definitely could have been done by one person. Now, after his arrest, Mr. Hernandez did not have to talk to the police. As you know, Mr. Zuazo did not. He could have remained silent, but he didn't, because he wanted the deputies to know that he was not part of the beating of Mr. Murray, and he wanted to tell them that. Now, it's usually not appropriate to talk about someone's size, but because it's been such a topic of conversation here, Let's talk about it. Remember the video of the interview in Louisiana. At that time, my client was booked into the jail at 450 pounds. As you could tell from those Lowe's videos, he had some trouble walking, and if you watch at the end of that interview, he could barely get up from the seat. Now remember back to the photos of where Mr. Murray was found. That space is extremely small. I argue that there is no way that Mr. Hernandez could have been the one attacking Mr. Murray. One, I don't think he's physically able to, and keep his mask on. And two, there wasn't room. Now, Mr. Hernandez was open and honest about the fact that a truck was stolen, signs were made, outfits were purchased, forms were printed out, badges were made, clipboards, duct tape, zip ties. They bought hard hats. We saw them at Lowe's and Home Depot. All in elaborate preparation of a larceny, not a murder. You did not see them at a gun store. You did not see them buying weapons of any sort. That is because it is clear from the evidence and clear from what Mr. Hernandez kept saying in his interview. It was not supposed to happen. Mr. Murray was not supposed to die. For that whole hour, Carlos kept the same tone, the same mood, until he was asked one question. If you killed the husband, why would you leave the wife alive? It was not supposed to happen. There was never a plan to kill Mr. Murray. If there was a plan to kill, why would you need to bind someone with duct tape? If someone is dead, they don't need to be bound. Think about that. They chose to walk in with tape instead of a weapon. Does tape show intention to kill? I argue no. Dr. Bryan told you that the duct tape on his hands and feet and mouth did not kill him. If there was a plan to kill, once the gun was removed from Mr. Murray by, I believe, Mr. Zuazo, why wasn't he shot? Why then wasn't Mrs. Murray shot? Now let's talk about the mention of an insurance policy in the interview and the correlation to the black bag found in Mr. Hernandez's Jeep. In that black bag, we were told Mr. Zuazo's boots, gloves, hat, and 2 masks were located. DNA clearly shows that those items were his, and they match what he wore on the Ring camera. Now, how did Mr. Murray's DNA end up on the large white t-shirt and the shoes of Mr. Hernandez? Well, unfortunately, Mr. Hernandez does not have the years of training regarding biological substances like the evidence technicians. Mr. Hernandez's own clothing was found in the same plastic bag as the bloody items from Mr. Zuazo. We learned about DNA transfer and degradation. If Mr. Hernandez had blood on him, Mrs. Murray would have seen it. I asked you in voir dire if you understood that you were not here to decide if Carlos was a nice guy, if you'd like to have him as a neighbor, or if you'd like him to have him date your daughter. Do you remember that question? And why is that important? Because again, even if you don't like him, none of the elements are satisfied by that fact alone. You may not like any of the actions that Mr. Hernandez took leading up to October 10th, on October 10th, or October 11th. The fact that he did some bad things does not then automatically mean that he committed the acts for which he is charged. Now I want to talk about the actual charges now. So we know the first count is first-degree felony murder. To prove this charge, the prosecutor must prove each and every one of the following elements. First, Mr. Hernandez caused the death of Hussein Murray, that he died as a result of neck compression and blunt force trauma. Second, Mr. Hernandez had one of the 3 states of mind. He intended to kill, he intended to do great bodily harm, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of Mr. Murray, that Mr. Hernandez was committing or attempting to commit or helping someone else commit the crime of larceny. And as we all know, after the end of 3 days, a larceny is a taking of property with intent to permanently deprive the owner without consent. Now, did the prosecutor prove to you beyond a reasonable doubt that it was Mr. Hernandez that caused the death of Mr. Murray? I argue no. The prosecutor now gets two bites to this apple here. They are either arguing that yes, it was Mr. Hernandez who actually did the beating death of Mr. Murray, or if you don't believe that, then he is still guilty under aiding and abetting. This instruction is so important and actually very helpful to you when you go back in that jury room, so I want to go over it. The judge is going to tell you to prove the theory of aiding and abetting. The prosecutor must prove all of the following elements beyond a reasonable doubt. First, that the alleged crime, which is felony murder, was actually committed either by Mr. Hernandez or someone else. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. And third, which is the absolutely most important element. Third, at the time, Mr. Hernandez must have intended the commission of felony murder, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. Was murder a natural and probable consequence of the commission of larceny? I argue absolutely not. And because of that, you have to find Mr. Hernandez not guilty of felony murder. These two individuals did not bring a weapon. They walked in the home with fake DTE equipment and duct tape and zip ties. Death was not the natural and probable consequence of those actions. It is clear that Mr. Hernandez went into that house thinking he could make some fast cash and get a house. There has been absolutely no evidence that Mr. Hernandez went there with the intention to kill anyone in that home, and because of that, I argue felony murder was not proven. Now, Mr. Hernandez is also charged with 2 counts of unlawful imprisonment. As we discussed in openings in voir dire, there's 1 count as to Mr. Murray, 1 count as to Mrs. Murray. The elements are the same. For count 2, unlawful imprisonment against Mr. Murray, I do believe that the prosecutor has proved the elements of this charge under the aiding and abetting theory we just went over. Mr. Hernandez went into the house after purchasing duct tape and zip ties that he shared with Mr. Zuazo. I believe the evidence then shows Mr. Zuazo used those items to restrain Mr. Murray. The binding of Mr. Murray was a natural and probable consequence of him walking in there with that tape. I believe the prosecutor proved that to you. As to count 3, unlawful imprisonment against Mrs. Murray, I do believe that the prosecutor has proved the elements of this charge. The testimony of Mrs. Murray indicates that it was Mr. Hernandez who used duct tape on her wrists and ankles prior to leaving the home. The verdict form will not say guilty or innocent. The verdict form will say guilty or not guilty. And by voting not guilty, you are voting not proven, that the prosecutor has not proven his high burden. I ask on behalf of my client, Carlos Hernandez, that you return a verdict that is consistent with the law, consistent with justice, and a verdict that is supported by all of the facts and evidence that you have heard in the last 3 days. And that would be a verdict of not guilty as to count 1 and guilty as to count 2 and 3. Thank you very much.
Thank you, Ms. Loftton. Any rebuttal here?
Briefly, Judge. Again, defense counsel starts off with talking about a plan to kill when they arrived at the house. That is not what felony murder is. That's first-degree premeditated murder. That's not how you're going to be instructed regarding the elements to be proven in this case. I would also say that there's a couple definitions that I maybe take issue with or need to be amended after this case has gone through. The first one would be forthcoming in describing the defendant's statement to the Oakland County Sheriff's detectives. What I heard, and I think it's only got little worth, but I don't think it was very forthcoming when he was talking to the detectives. If you recall, which I thought were the highlights of it, defendant says, when he's supposed to be forthcoming with the detectives, he says, "I never said I was there the second day." I never said I was there the second day when all the bad stuff happened. At that point, he's trying to portray himself as only being there on the 10th, where nothing really bad happened. That was forthcoming statement number one. Then you remember he was asked about Mr. Murray fighting back. There was no response to that question at all. Silence. He doesn't want to talk about what happened in the basement with Mr. Murray. And then, shocking, he says, when asked about hitting Mrs. Murray, he says, I don't recall hitting Mrs. Murray. That was another one of his forthcoming statements that he made to the police officers. And the final term that I would change is that this was an insurance policy for him, because what he had in that black bag was anything but an insurance policy for him. Now, there was a statement about his mask not being in place and there should be more blood on the defendant. More blood, we need more blood. Well, you hear from the first deputies on scene that they're reporting as a gunshot wound. That's how much blood there is at that scene, that they believed it was a gunshot wound. That's how much blood was there at the scene. We need more blood? Okay, well, the facts give you more blood. As you heard the testimony, you have the exhibits for the defendant, C and D, that are moved into evidence. In the stuff that's found with them, face covering N95, red stain on the exterior. Defendant Hernandez on the interior. Both victims on the exterior of that. Defense wants more blood? Okay, well, 7E, white t-shirt, which is into evidence before you. Swab both the inside and the outside. Defendant Hernandez on that 6XL t-shirt is in the interior. Victim Sam Murray is in the exterior of that exhibit. More blood still? We've already talked about it. Those black Nikes. But not only is there the blood of the victim on the outside of those shoes, the blood of the victim and his DNA is inside the shoe also. That's how intimately connected the defendant is with that bloody scene. And then finally, as we also discussed, 7G, the black gloves that were found on the defendant when they were stopped. Exterior victim of the victim. Interior is defendant Hernandez. Also interior is victim Linda Murray. So, I guess the best response I can have about trying to have it both ways, I believe that was said at some point. At no point have I ever theorized that only one of the defendants obliterated Mr. Murray in that basement. I don't believe only one of those defendants had contact with him when this was occurring. I believe both defendants had contact with him down in that basement when he put up that struggle, because they have to disarm him. And disarming him first is probably one of the main priorities. But then he's attacked from the back and his head is bleeding. Now, I tried to think about, a response to that. But growing up, I have a brother. He's 4 years younger than myself. Okay, so growing up, for a long time, I was the older brother. And when we roughhouse and play around and wrestle and stuff like that, I could get both of his arms, his wrists in one hand and hold him down with one hand and a second hand free to tickle him. I don't know what you want to say, but you could hold both arms in one hand. When he got older, I couldn't do that anymore. And if we were going to struggle, it would take a hand in each hand to do it. Now, Mr. Murray is a big guy. Mr. Murray is struggling. There is no way that you're holding down Mr. Murray as he's struggling with one person and then binding him in that position. There is no way one hand is holding him with one hand and tying him with duct tape with the other, with zip ties. Impossible. Both of those guys were doing that down in the basement. They have the blood of the victim on it to prove it. You don't get blood on you like that if you're upstairs with Mrs. Murray asking about where the safe is. I believe the evidence has clearly shown that the defendant is guilty of charged of the murder and of the other 2 counts. I appreciate your time and attention. Thank you.
Arguments in this case are finished. I will now instruct you on the law. That is, I explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinion of the other jurors who might have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given some instructions about the law. You must take my instructions all together as the law you are to follow, and you should not pay attention to some instructions and ignore others. To sum it up, it's your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide this case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made of parts called elements. The prosecutor must prove each element of a crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes sworn testimony of witnesses, exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'm going to describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments and commentary are also not evidence. They're only meant to help you understand the evidence in each side's legal theories. You should only accept the things the lawyers say that are supported by evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses are not evidence, and you should only consider these questions as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during trial, I've excluded evidence that was offered or stricken testimony that was heard. Don't consider those things in deciding this case. Make your decision on only evidence that was let in and nothing else. Your decision should be based on all the evidence, regardless of what party produced it. And you should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge that you have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witness you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You're free to believe all, none, or part of a person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you have based on a witness's disability, race, national origin, or ethnicity, gender, gender identity, or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be an automatic or instinctive judgment and reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it might help you to think about these questions. Was the witness able to see and hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did this witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? And all in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, or whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with all the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. And if so, you may choose not to accept anything the witness says. On the other hand, if you think the witness has lied about some things but told truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must prove beyond a reasonable doubt that this crime occurred on or about October 11, 2024 in Oakland County, Michigan. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you consider such an out-of-court statement against the defendant, you must find that the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in this case. You may consider the statement in deciding the facts of the case. Water break. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. But facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that's circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial and direct evidence, can be used to prove the elements of the crime. In other words, consider all the evidence that you believe. There's been some evidence that the defendant ran away after the alleged crime. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. You have heard evidence that before the trial, a witness made a statement that might be inconsistent with their testimony here in court. You may consider an inconsistent statement made before trial, but only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. When the lawyers agree on statements of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, think about what each witness in each piece of evidence and whether you believe them. Then you decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer talked to one of the witnesses. There's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from witnesses who have given you their opinion as experts. Experts are allowed to give opinions in court about matters that they are experts on. However, you don't have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. And when you decide whether you believe an expert's opinion, think carefully about the reasons and the facts that they give for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about all the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. As to count one, the defendant is charged with the crime of first-degree felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Hussein Murray. That is, that Hussein Murray died as a result of neck compression and blunt force trauma. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Hussein Murray, or he knowingly created a very high risk of death, or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of Hussein Murray, the defendant was committing or attempting to commit or helping someone else commit the crime of larceny. For the crime of larceny, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant took someone else's property. Second, that the property was taken without consent. Third, that there was some movement of the property. It doesn't matter whether the defendant actually kept the property or whether the property was taken off the premises. Fourth, at the time the property was taken, the defendant intended to permanently deprive the owner of that property. The defendant must have been either committing or helping someone else commit the crime of larceny. To help means to perform acts or to give encouragement before or during the commission of a crime that aids or assists in its commission. At the time of giving aid or encouragement, the defendant must have intended the commission of the larceny. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant or someone who he aided or abetted caused the death of Hussein Murray. That is, that Hussein Murray died as a result of neck compression and blunt force trauma. Second, that the defendant or someone that he aided or abetted had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Hussein Murray, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that the killing was not justified, excused, or done under other circumstances that reduce it to a lesser crime. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer that the defendant intended to kill if he used a dangerous weapon in a way that's likely to cause death. Likewise, you may infer that the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. As to count two, the defendant is charged with the crime of unlawful imprisonment. To prove this charge, the prosecutor must prove the following beyond a reasonable doubt. First, the defendant knowingly restrained Hussein Murray. Restrain means to forcibly restrict a person's movements or to forcibly confine the person so as to interfere with the person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, the defendant did so under one or more of the following circumstances. The restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret, or the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of another felony. As to count 3, the defendant is charged with the crime of unlawful imprisonment. To prove this charge, the prosecutor must prove the following beyond a reasonable doubt. First, that the defendant knowingly restrained Linda Murray. Restrain means to forcibly restrict a person's movements or to forcibly confine the person so as to interfere with that person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, that the defendant did so under one or more of the following circumstances. The restrained person was secretly confined, which means to keep the confinement or location of the restrained person as a secret, or the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of another felony. In this case, the defendant is charged with committing first-degree felony murder and 2 counts of unlawful imprisonment or intentionally assisting someone else in committing it. Anyone who intentionally assists someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abetter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the alleged crime was actually committed either by the defendant or someone else. It does not matter whether anyone else has been convicted of the crime. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. Third, at the time, the defendant must have intended the commission of the crime alleged or must have known that the other person intended its commission or that the crime alleged was a natural and probable consequence of the commission of the crime intended. If the defendant knew that the alleged crime was planned or was being committed, the mere fact that he was present when it was committed is not enough to prove that he assisted in committing it. When you go to the jury room, you're going to be provided a copy of the written final instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has had a fair chance to be heard. During your deliberations, please turn off cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agree on that verdict. In the jury room, you will discuss this case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I have already given you instructions regarding a lesser offense. As to any count which includes a lesser offense, you must first consider the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offense. If you believe the defendant is not guilty of the principal offense, or if you cannot agree on that offense, you can consider the lesser offense. It's up to you how long you take to decide or consider the principal offense before discussing the lesser offense. You may go back to consider the principal offense after discussing the lesser offense if you want to. If you have questions about jury instructions before you begin deliberations or questions about the instructions that arise during deliberation, you will submit them in writing in a sealed envelope to the court clerk. Possible penalties should not influence your decision. It is the duty of the judge to fix fix the penalty within the limits provided by the law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court clerk. It's not proper for you to talk directly with me, the lawyers, court officers, or anyone else involved in this case. As you discuss this case, you must not let anyone know, even me, how your voting stands. Therefore, until you reach a unanimous verdict, do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take your notes and the full instructions. If you want to look at any or all the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you're going to be given a written copy of these instructions, as I've already told you. My instructions together are the law you are to follow. The defendant is charged with 3 counts. That is, with the crimes of first-degree felony murder and 2 counts of unlawful imprisonment. These are separate crimes, and the prosecutor is charging that the defendant committed all of them. You must consider each crime separately in light of all the evidence in this case. You may find the defendant guilty of each or any one, any combination of these crimes, guilty of a lesser crime, or not guilty. A verdict form has been prepared, and the verdict form is going to have the title and case number on the form, and the verdict form is going to list each count, and I'll read it to you. Count 1 says first-degree felony murder. There's a box to check, the first box that says not guilty. The second box says guilty as charged of first-degree felony murder, and the third box says guilty of the lesser offense of second-degree murder. Count 2 is unlawful imprisonment. The first box says not guilty. The second box says guilty as charged of unlawful imprisonment. Count 3 is unlawful imprisonment. The first box says not guilty, and the second box says guilty as charged with unlawful imprisonment. You are to check the box as you reach your verdict. The foreperson shall sign and date the verdict form. All right, so those are all the formal instructions. Let me just kind of give you some procedural information at this point. So when you are taken back to the jury room, you're going to be given a buzzer, and that's the way that you're going to be able to communicate with the court. So anytime you want to communicate with me, you would write it in a note, put it in a sealed envelope, and then that information is brought to me. I'll explain that process in a minute. But with the buzzer, that's the way that my staff's going to know you need them. And if you do press that buzzer, someone will come to the door, knock very loudly, and say, "Stop all deliberations." That is because they want you to stop your deliberation, so please stop talking when they come in to get that note. They don't want to be in your deliberation, so please don't ask them questions. Don't hand a question to them and say, "This is what we want the judge to know," okay? They will certainly bring that note over to me. It is read by me, and then depending on what the question is, it is answered, okay? All questions are answered. Here's the things that we are not going to bring you back into court to answer. I don't manage your time, so if you go back there and you need a break, I know you guys had a long break today, but if you need to take a break, and you're taking a break within your own jury deliberation room, I don't need to know that. No one needs to know that. The only time I need to know is if you're taking a break and you're leaving your deliberation room. So in that case, write a note, let me know, "Judge, we're going to take a 20-minute break and we want to leave this room," and somebody will come back to let you know if you are able to leave at that time, okay, or when it's appropriate to leave. If you ask for evidence, any objection to having the evidence given to the jury upon asking?
No, Your Honor.
No, Your Honor.
Okay, so the reason I'm asking the lawyers that is any other question that you ask outside of those breaks and the evidence are going to require me to reconvene court. So it means we all come back into court like we are now. That question is read out into the record to the lawyers, and the lawyers and I decide what the best way to answer that question for you is, and then you are brought back in here, and the question is answered in front of everybody, okay? Obviously, there's 2 juries at the same time, and it might take me a little longer to get back to you. It's not because we are ignoring it, it's because that process will take some time. I'm not telling you that to discourage you from writing a note. I just want you to know what's happening during that time period. So, evidence. The evidence, there's some evidence here that is sealed evidence. All right, you're allowed to look at any piece of evidence if you want to. If you're going to ask for that specific evidence that is sealed, you're going to need to let me know that in a note that you want to see that. and it will be brought back to you, but then we'd also provide everyone with gloves to make sure that there was no contamination if you want to take something out, okay? So just be specific about that. There's also digital evidence. You're not going to have any electronic equipment to play the digital evidence unless you ask for it. So if you want to see something digital, let me know and say, we're going to be the device to see it. And if you're not sure, just ask for the technology and I'll get it back for you. But I can't bring it back for you unless you ask, okay? There's 14 of us, only 12 are required for a unanimous verdict in a criminal case. So we draw lots to determine which 2 of you are going to be excused as alternate. It's my understanding that we already have your names and your phone numbers, so if you're excused, you are free to go for today. However, it is not a common practice for an alternate to be called back, but it has happened. And in a case as lengthy as this one has been, it wouldn't be out of the ordinary if you were called back. So the restrictions that I gave you originally regarding not sharing this information with family, not posting, not speaking to media, all of that stuff still applies. I will promise you this, okay, and we're very good at doing this. If you're an alternate and we get a verdict, you are the first call after we take that verdict. You are told that the verdict has come in, and if you'd like to know what that verdict is, we will share that with you. Okay? All right, let's 2 people, please.
Juror number 8.
That's you, sir. You can stay seated. We'll let you go when everyone goes back.
And juror number 5.
And that's you. Okay. All right. Thank you both for your time and service. And as I said, all the restrictions will apply until you get a call from chambers. Okay. Anything else I'm forgetting with the
No, you're not. People are satisfied with the instructions.
You're satisfied? Okay. I'm just going to go in and just swear in my clerks now. Please raise your right hand. You do solemnly swear, no, not you guys, my clerks, you do solemnly swear that, but I can see how that's confusing. You do solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them, orally or otherwise, and that you will not communicate with them or any of them, orally or otherwise, except by order of this court or to ask them if they have agreed on their verdict, until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God. Okay, all right, thank you. Ladies and gentlemen, we'll send you back to your jury room.
All rise for the jury.
It's honestly it's 5 o'clock, but I'm gonna keep them a little bit later. I think that at least give them an opportunity to be able to have initial discussions and choose a 4-person. So
Yes, Judge.
I'm gonna say 5:30 or
As
6.
long as you need, Judge.
Yeah. Okay. I appreciate it. Are you good with that, Ms. Loftton?
Yes, ma'am.
Okay. And I obviously understand that everyone. It's Friday evening. Okay. So I will be considerate of your time. Okay. All right. Thank you.
All rise.